Wait, please, your lords. What's been item number 16, we have circulated adjournment petition yesterday. Matter may come up after 2 weeks.
Item number
16.
15, 16. Okay, there are adjournment scripts. Both sides represented on the prayer made by the counsel for the petitioner. The John Today, please come to the rules. Yes.
Please, your lordship, I beg to mention item number 11, worship. My seniors.
11 will have to refuse. You have to wait till the matter reaches. Without advance notice on Tuesdays and Thursdays, we are not adjourning.
Seniors.
Mr. Talukdar, this matter today, we'll take it up then first. Item number 2.
Item 17. There is meaning.
Oh. It was 25, is it 15 over again?
Oh.
Not
To be spoken to item 17.
both sides are represented. After delivery of the order dated 12/8/2025, it has been pointed out before the court that that a typing error has crept in paragraph 6, and the date 16/10/2025 referred therein should be read as 16/10/2015. Next, accordingly, the date 16/10/2025 appearing in paragraph 6 of the order dated 12/8/2025 passed in WBC 3728 of 2025 shall now be read as 16/10/2015.
Hmm. 2015. May
You see, Mr. Sharma, I think somebody pointed out to the courtmaster that in this writ petition, bail was granted in the IA. And on disposal of the IA, on the disposal of the writ petition, the IA will merge.
Yes.
So do we have to say anything in this main case also about the bail granted in IA? We had allowed here in the IA as well as in the writ petition.
Yes, Lord.
So normally the orders in the IA will merge in the
Writ petition.
writ petition.
Yes, Lord.
So do we have to make a mention here in this
No,
about the bail?
No. Regarding bill of.
I response now. Lordship, it will be 2015, Lordship.
That's what I've said. 2015. Just we add one word.
To remand pulito. Expert to remand pulito. I have nothing to.
After paragraph 10 of the order, you say like this. After paragraph 11 of the order, a new paragraph numbered as paragraph 12 may be added in the order dated 12/8/2025, clarifying that bail has been granted to the petitioner in IA Civil 2562 of 2025, which was also disposed of by order dated 12/8/2025. Next paragraph. This order shall be read together with order dated 12/8/2025 passed in WPC 3728 of 2025.
Since Lordship, since earlier, since matter was remanded back Lordship, so it will be proceeded appraised Lordship. And Lordship, so further condition of bail will be considered by the learned tribunal Lordship.
No, it's there in the IA. I-
তো মাস হয়ে গেল তাহলে গো ম্যাটার্স তো কোথায় হয়ে গেল গতিকে
Then
further
we have added paragraph 12, let's say. On evidence of the petition before the learned tribunal, the tribunal shall pass appropriate orders to the as it may deem fit and proper.
Yes.
Yes, we are calling item number 2. Sorry, you made a mistake in your name in the last order.
I was also thinking, Milord, the person who we could not locate the amicus curiae. But
No, Shakespeare said, what is in the what is in the name after all? A rose with any other name will smell as good. So we go by Shakespeare. Yes,
Lordship, in the last date of hearing, amicus curiae was printed.
we wanted the amicus curiae to address the court. Just
yeah, Yeah, I was referring to the report of the one-man committee. That report starts at page 157. I have read 8.6. Para 8.6 I have read. Kindly come to 8.7. At page 165. Interactions with Rimli Soikia, sister of Dipankar Gogoi, and Srimati Bonti Buragohai, maternal aunt of Dipankar Gogoi, were not of much help, as they do not reside at the house of late Dipankar Gogoi or at Birina Sayap, Titabar, and only provides details conveyed by his parents. They come only after coming to know about the death of Dipankar Gogoi. Their attempts to share information seemed restrictive, hindering direct communication with Hogan Gogoi and Srimati Dipti Gogoi. Rimli Saikia arrived when the body of the deceased was being taken down from the hanging stage. She informed that the feet of the body were just touching the ground and reported that there were injury spot on the back side of the buttock and also at the lower abdomen area. Rinku Rajak, Himanshu Hendrik, and Ataur Rahman were examined separately, wherein they stated that they were picked up by Jorhat police for interrogation on 25/12/23, where they met Dipankar Gogoi. They sat in the same waiting area and had food together. Their medical examinations were also conducted together, after which they were dropped back at their respective homes by police on 26/12/23 between 1:15 to 2:30 a.m., during which Dipankar Gogoi was first one to be dropped at his house. I have gone through the medical examination report of these three persons. Two organizations, Krishak Mukti Sangram Samiti Assam and Jorhat Jila Sochetan Mohila Mancha, submitted memorandum on 8 January 2024 at public sitting at Pitabar. The memorandum raised question about Dipankar Gogoi's alleged fear of being shot if he didn't confess, and demanded public clarification on his association with the grenade blast on 14/12/2023. Copies of the memorandum were there. Then the examination of magistrate conducting inquest and doctor who performed postmortem, those are also seen. Kindly come to para 10, analysis and findings. Ten point five. The medical examination reports of all 4 days dated 23/12/23 to 26/12/23 consequently indicated no external injuries during examination. Additionally, the photograph of Dipankar Gogoi was taken with his mother on 26/12/2023 at 1:15 a.m. revealed no visible signs of distress. Contradictions arose concerning the 5 ointment scripts that I have read below. Then 10.6, the CCTV footage of Jorhat PS for 23rd and 25th of December, the day preceding his death, from the time he was brought to police station till 11:45 p.m., that is till he departs from the police station, did not show any distress displayed by Dipankar Gogoi. It was observed that most of the time he was sitting with 3 other suspect persons in the traffic branch, and he was called in the chamber of OCPS for 2 times for a total duration of not more than 1 hour 10 minutes. During these instances, he was observed consuming some food, dinner. The footage does not indicate any apparent distress or discomfort displayed by Dipankar Gogoi throughout this period. The CCTV footage of Titabar PS, where Dipankar Gogoi was interrogated on 24th and 20 December, was not made available for viewing, stating that it was not possible to retrieve old footage. There was no CCTV at the police guest house, Jorhat, where Dipankar Gogoi was interrogated on 22nd December 2023, as per police version. Well, this CCTV footage of of Titabar PS, subsequently it was retrieved and it is now placed before your lordship, well, it is there. Then he has also examined on examination of photographs of the inquest, two rounds marks resembling blood clots. Two rounds marks resembling blood clots.
Itu mari again. But why they have not sent the original order for calling of the records was passed on 25/6/2025. Can it come by day after tomorrow?
Lordship Friday, no.
Friday will be some difficulty.
Then
Because
Lordship
again,
without fail, Lordship on Tuesday, Lordship.
huh?
Tuesday, Lordship without fail, Lordship. Tuesday.
Because he's in custody from, he is in custody and paying for bail.
Yes, sir.
He's in custody from 25, 15/5, 16/5. Pardon me?
Statement was fine. Thereafter, 1 days, you should give it.
No, we understand, but then Tuesday, otherwise we'll grant bail. We make it clear.
Lordship, Tuesday, Lord.
Mr. A.M. Khan, the counsel for the petitioner, is present. First of all, he submits that there is urgency in the matter as the petitioner has been taken into custody on 16/5/2025 and is presently lodged at the transit camp, Matia, Gwalpara. First off, he also submits that the petitioner is not in good health, for which an interrogatory application has also been filed for bail. Next para. In this case, an order was passed on 25/6/2025 to requisition the records. And the requisition was sent on 9/7/2025 by usual process as well as by email. However, the Foreigners Tribunal, Bongaigaon number 2 at Abhayapuri has not sent the records of the proceedings of case number. Page 34. Next para. Taking note of the same, this court by order dated 6/8/2025 had requested the learned standing counsel for the FTN border matters to obtain the case records from the said learned tribunal through the concerned authorities in the home and political within bracket B, bracket close department, government of Assam. Next para, Mr. G. Sharma, learned standing counsel for the FT and border matters has submitted that though he has communicated the order, but the records have not received. He prays for one last opportunity one more opportunity to produce the records on 26/8/2025. Next panel, all the other respondents are also represented. Next para. In view of the prayer made by the learned standing counsel for the FT matters, one last opportunity is granted to the authorities in the Home and Political within bracket B department, Government of Assam, to obtain the records of the case referred above from the concerned tribunal. Next para. It will. Focus করে দিও না। Next para. In the meantime, as requisition has already been served on the Foreigners Tribunal, Bangladesh number 2, Abhyapuri. Next, court is inclined to issue show cause to the superintendent of the said learned tribunal to explain the reasons why, despite receipt of the notice from the court, the records have not been sent. Next paragraph is said, next paragraph, the registry shall communicate a downloaded copy of this order to the Foreigners Tribunal, Bangladesh numbers 2, Abhyapuri, in the following email address. This you will find in order dated 25/6/25, the address of tribunal. Full stop. A communication of this order shall constitute notice on the superintendent of the said learned tribunal for showing cause within 15 days from the date of receipt of the notice through the copy of this order through email. Most of the show cause reply shall be filed by way of an affidavit. Next para. For the purpose of the show cause issued on the superintendent of the learned tribunal, the next date would the next date would be eight 9/2025. Date 9, make it 10/9, 10/9/2025. Next para, however, for consideration of the prayer for bail and for production of the case diary for the Home and Political B department, one is the matter on 26/8/2025. We are fixing two dates. One is for the regular show cause and one for this.
Item 3 for hearing.
Just a moment. You see, we are not adjourning the matter because this matter was dismissed for default earlier. Thereafter, we have restored it. After that, we'll find it very difficult. It will be, no? I to do. Yes. Please repeat again. No, but you see here the reference was what do you call the question posed was decided long back. Thereafter, this matter was dismissed for default in 2019. We condone delay of 543 days to restore this file. Delay of, after that, few dates have been gone. 2016 matter. Okay, all sides are represented. The learned counsel for the petitioner pays for adjournment. So we take note of the fact that a preliminary issue raised in this writ petition was decided by order dated 8/3/2018. So thereafter, as the learned counsel for the petitioner remained unrepresented when the matter was called earlier, the writ petition was dismissed for non-prosecution by order dated 16/5/2019. Thereupon, on an application for restoration filed by the petitioner, by order dated 16/12/2022, the delay of 543 days in filing of the restoration application was condoned. And this writ petition was restored to file. Next, by under such circumstances, the prayer for adjournment made by the learned counsel for the petitioner is not acceptable. Next para. For ends of justice, the matter stands adjourned today. Next para, list on 26. Right, list on 21/8/2025. So no, therefore adjournment will be considered on the set date. 21st. No, that cannot happen unless your senior should not have left the court like that. It's not appreciated. We have made it very clear that Tuesdays and Thursdays, there will be no adjournment. Then to leave the court midway is not acceptable. We'll hear that matter even without your assistance. One matter we have adjourned, we can't adjourn the entire board. Everybody will have problems in hearing. This attendance you will not file in the bail bench. The thin attendance in this courtroom, you will not file in the bail bench. I am not very impressed. Okay, on that ground, we adjourned that also. 21st, no adjournment. If you're saying medical, we. And item 6, and item 6 only you say that the prayer for adjournment, prayer for adjournment, the matter stands adjourned today based on so and so, on which date no adjournment shall be granted. Yes.
Item 4,
May I please, Your Lordship?
Just a moment. The opinion is at page 39.
Page 39, my lord, is the, my lord, type copy, my lord, because from the LCR also, my lord, I have gone through the LCR. The impugned judgment seems to be a little bit dim, my lord.
Okay.
Therefore, my lord.
Who was DW2?
DW2 is his maternal uncle, my lord.
Okay.
And regarding, my lord, the depositions made by the other DWs, my lord, including the petitioner, my lord, and some of the vital documents which were exhibited before the concerned tribunal, my lord, the learned tribunal did not whisper a single word, my lord. And in fact, my lord, the reference, and go through the all the, my lord, records, my lord. The reference itself seems to be, my lord, defective, faulty and mechanical. For a moment, before going to the impugned judgment, if your lordship kindly goes to the, my lord, reference, my lord, that is at annexure 5, page 28, my lord.
The reference of this nature we have already dealt with in
Yes,
other
my lord,
matters.
there is a number of, in fact, my lord, the full bench of this honorable court has also clarified this issue. And there is a,
Perhaps you have not read that judgment.
not all the
Perhaps-
judgments.
Full bench judgment you have not read, or you have not been able to understand this reference made here. This is a reference by ERO. It's got nothing to do with police reference. So your full bench doesn't help you in any way.
I'm trying to point out one thing, my lord, from the reference. If your lordship kindly turn to page 28, my lord, this will be very clear how mechanically it was made, my lord.
But that is not even required. This form is not even required to be filled up. He'll just have a doubt of a particular person being a
For that,
voter.
There has to be a physical verification, my lord. That verification was never conducted. And I vehemently
You
oppose
have
to
seen
that.
you have seen the present situation in the Bihar with, which is going on with the SIR.
Yes,
Same thing. It's an extensive regional role. Just it has to be a doubt created. That's all.
you know, the very basis of the doubt, my lord, itself seems to be defective, my lord. My lord will kindly have a look at page 28.
I am there at page 28.
Yes, my lord. Lordship will kindly see, my lord, in the physical description column, the name of the proceedee is Hadrat Ali, my lord. Everybody, my lord, from the name itself, it clearly reflects that he's a male, my lord. In the sex, it is written as female, my lord. And in the ground for having reasonable doubt at column number 11, my lord, it has been specifically mentioned as the suspect person entered into India within bracket Assam on or after 25th March 1971, as could not produce any document that she is an illegal migrant. Therefore, I am submitting before your lordship, my lord, that this has been, my lord, prepared mechanically in a defective manner.
Yes.
She has been termed as female, my lord. This procedural in Hazrat Ali. Regarding this, if I may go to the para 98 of the Muslim Mandal's case, my lord, for a moment, if your lordship kindly have a look in the full bench judgment, my lord.
You'll find mistakes of this sort in many of our orders.
Yes, my lord.
You will find it. What happens is that when we are discussing about the proceeding,
Yes,
and then at times he becomes she and she becomes he.
well, but whatever, what happens, my
Even
lord,
in our orders, the first matter we took up today was a matter of correction of our order. Date of 2015 was misread as 2025. So we make mistakes. He and she is not too much of a. And this Muslim Mandal doesn't help you. This does not relate to the investigation by electoral what do you call registration officer. So
if
no
I may
paragraph
refer,
will
my
help
lord,
you.
one another case of this, my lord, coordinate bench, my lord. The same issue, my lord, has been dealt with, my lord, by the coordinate bench of this honorable court, my lord.
ERO.
Here, not ERO's report, and regarding this reference, my lord, this kind of reference. If
No,
Lordship
that-
will kindly allow me to produce, my lord.
This judgment is of reference by ERO.
Now, later on, in that
Amina
time,
Khatun's case
distinguished.
was distinguished.
Amina
by-
Khatun's case, my lord, that has been distinguished later on, my lord. And for a moment, if I may refer this, my lord, case, my lord. Yes. It almost covers my case, my lord, this Amina Khatun's case.
Amina Khatun distinguished by the
What is-
honorable.
what is- मैं रेफर कर कारण है Lordship will kindly have a look at page, my lord, serial number 5, my lord, point number 5. On perusal of the records, we see the reference was made by the superintendent of police border on the ground that the person namely so and so, wife of so and so, is a doubtful voter. The said reference is based on certain reports of the ERO, which is in turn based on the LVS report. In the ERO's report, which is based on the LVS report, some doubt has been expressed about the citizenship of the aforesaid person. However, when we see the LVS report, we have noticed the entire format is blank except the name and mentioned as Amina Khatun, wife of so and so. As regards the various other particulars required to be filled up, there is nothing mentioned except the word absent on the top of the format. If the basis of the doubt of the citizenship of the person is based on LVS report, we are of the view that since the LVS report is devoid of any particular or any finding or for that matter any remark or observation, the said reference cannot be said to have been made after proper application of mind. In Muslim Mandal Supra, the full bench of this honorable court had observed that fair investigation and fair trial is one of the basic fundamental rights of a person. And it has been also observed that though investigation need not be detailed or an exhaustive one, keeping in view the nature of the proceeding of the before the tribunal. The reference by the referral authority cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during his investigation and make the reference on being
That
satisfied.
is the fundamental error in this order.
Yes,
You see, he is not an investigating officer.
my lord.
He is only a person who is deputed by the electoral officer to make an inquiry. These people may be a officer of the what you call any department. He can be a school teacher.
Yeah.
So
Some
a school
agriculture
teacher
officer
or this
also.
person, they are not investigating officers.
Yes,
That is the fundamental reason why we have deferred with it.
yes, my lord. In
This
the LVO reports
this
also, my
person
lord.
who has signed is Manavendra Nath Sharma. His designation also is not given, but he is engaged by the electoral registration officer.
Yes. Designation is not.
He is
given.
not an investigating officer. They are not trained to be investigating officers.
He's not an investigating officer, but the, kindly see the format, my lord. The form is almost blank, my lord, lying. Where is the ground of suspicion? How he have come to, my lord, the territorial boundary of India? Nothing has been specified. My lord. It is the ground of suspicion, my lord, that has not been, my lord, stated by the concerned officer, my lord. He may not be, my
You
lord.
see, that's why we are saying, we are telling you, Mr. Ahmad,
My lord,
unless you know the background, you will not be able to assist us.
yes,
The electoral registration officer works under the Representation of the People's Act. It had nothing to do with foreigners. They just create a doubt that this man is a doubtful voter.
yes,
He is not a person who is investigating under the Foreigners Act. That is the fundamental issue we have to we are required to answer.
yes,
An electoral officer has no business under the Foreigners Act.
Yes.
Or under the Citizenship Act. He is not working under both the law. How does it matter then?
Lord, I am referring this reference, my lord. Since the reference is the basis of
We
a,
have answered it. That's why we are telling you. Before you started, we said we have answered it
My
in another matter.
Anyway, my lord, I'm going to the, my lord, impugn order, my lord.
Hmm.
Yes, my lord. Page 39 is the impugn order, my lord. And the operative portion starts at page 40, my lord.
But I will not be able to remember the order. 2 days back, I gave one.
Yes, okay. WBC 245 of 2019.
W,
WBC 245 of 2019. Sukurjan Nesa. WBC 245 of 2019. Sukurjan Nesa. SUKURJANNESSA. Alias Sukurjan. SUKURJAN. Versus Union of India. Decided on 28th of February 2025.
28.
Yes, okay. 28.
28, 2011.
yes.
Yes. My lord will kindly come to page 40, my lord.
Just a minute.
WS is totally fake look.
Hmm?
WS. একই লিখা না উপরে রিপোর্টের কথা লিখতে এটা একটু দিয়া। There is no pleading lordship other than verification report lordship.
No, just, there's something else in the record. We wanted to show it to you.
Yes.
This proceeding is Hazrat Ali,
Hazrat Ali.
correct?
Yes, my lord.
But, and who is this Sabed Ali, DW2, who is he?
Samed Ali is his uncle, my lord, maternal uncle.
He's his uncle.
Uncle.
Now you see, you'll have to also tell us. The documents exhibited
Yes, my
was
lord,
by your uncle.
by his uncle. Yes, sir.
These documents were not exhibited by the proceeding himself, the petitioner himself.
Yes, my lord.
And there's nothing in this evidence. You have a copy of that evidence?
No, my lord, I could not, my lord. I'm sorry
take
for
this.
this.
No, it's okay. Yes, go ahead. Yeah, the document here. His source of knowledge we couldn't find. Take it, read it, take it with your hand. Take it, Mr. Amar. Take it, you read it.
No, this affidavit page or my lord, the
No, page number 10.
page number 10 is my lord, yes. Miscellaneous case number, so 26/15, reference number so and so, petitioner Muzammil Hussain advocate.
No, not this. I'll see at page 10.
Oh,
This is the evidence.
yes, yes, evidence paper. DW2 is Sabed Ali, son of late Abdul Hussain, Abul Hussain. He's from Bhojagati Gav, police station, Velowari. যি কম সঁচা কম মই অপৰপক্ষক চিনি পাওঁ মোৰ সম্পৰ্কীয় ভাগিন মই লিখা পঢ়া জানো মই হজৰত আলীৰ হৈ নথি পত্ৰ জমা দি প্ৰদৰ্শক এ গাঁওবুঢ়া প্ৰমাণপত্ৰ প্ৰদৰ্শক বি পঞ্চায়তৰ পৰা দিয়া প্ৰমাণপত্ৰ প্ৰদৰ্শক চি আৰু ডি অপৰপক্ষৰ দেউতা আৰু মাকৰ নামৰ 1965 চনৰ আৰু 70 চনৰ ভোটাৰ তালিকা প্ৰদৰ্শক ই অপৰপক্ষৰ দেউতাকৰ নামত 1955 চনৰ মাটি থকা দলিল প্ৰদৰ্শক এফ দেউতাকৰ নামত থকা 1970 চনত ভাৰতীয় নাগৰিক হিচাপে স্বীকৃতি পোৱা নগাঁও মুন্সিফ আদালতৰ ৰায়দানৰ কপি
He's a resident of where, how did he come, anything, nothing is there.
অপৰপক্ষৰ পৰিয়ালৰ ভালকে জানো তেওঁলোক বিদেশী নহয় অপৰপক্ষ 1997 চনত দি লগাত তেওঁ ভোট দিব পৰা নাই In the cross, he said that ভোজাগাঠি আৰু ভোজাগাঠি পথাৰ দুখন বেলেগ গাঁও অপৰপক্ষ ভোজাগাঠি গাঁৱত জন্ম হৈছিল অপৰপক্ষৰ মাকৰ নাম আমিনা খাতুন হজৰত আলীৰ ভাই ককাই তিনিজন Yes. But regarding his relationship with the petitioner, he has not stated anything, although.
No, not even that. How these documents show that he's an Indian, that also statement is not there.
Who may not be.
Exhibit A is so and so, exhibit B is so and so, how does it prove anything?
My lord, yes, my lord, that is there, but regarding this exhibit F, which is the, my lord, judgment copy, which was passed by the Munsif then, my lord. In the observation, neither nor in the findings, my lord, not a single word is whispered, my lord.
Yes, page 40.
Page 40 is the, my lord, only they have recorded. And regarding the observation and.
No, no, the observation is there.
The
Just read
findings,
that.
nothing is there in the finding.
6, yes,
In the finding,
we have read it. But it's-
page 40 minute, if I'm able to, yes. Opposite. part-
6. Page 40, serial number 6.
Six, yes,
Exhibit F is a copy of
German-
judgment of so-and-so, but
copy
this
of
copy is not a
judgment
certified
of
copy.
honorable court, but this
And the
copy is
seal and
not a
signature of the
certified-
honorable court concerned are also not legible, for which
Legible.
it is not admissible.
Admissible, yes.
What else is to be written?
This is a very old document, Lordship will kindly have a look, my lord, minutely, my lord. This exhibit F, my lord.
Exhibit F.
Exhibit F in the LCR, my lord. From the LCR, my lord, it shows that it's a very ancient document, my lord. Probably, my lord, everything is there and but it is not legible, my lord. The name of the, my lord, father of the petitioner as well
In
as.
in this, you see, that's the point. Provercock F. Devtar Namot.
Yes.
Now, whose father is not saying?
My lord,
Devta
his father,
Namot.
it implies, my lord.
No, we don't know.
It implies, my lord, that his father means, my lord, the petitioner's father, my lord.
We don't know.
Since it is said-
দেউতাৰ নামৰ থকা 1970 চনৰ ভাৰতীয় নাগৰিক হিচাপে স্বীকৃতি কৰা নগাঁও কি আদালতৰ দায়, correct? Now,
my lord, the uncle was making the deposition for the sake of, my lord, the petitioner. As such, he said that his father, my lord. His father implies that the petitioner's father, my lord.
now you see,
My lord.
this is even going without going to the merit of the matter.
Yes, my lord.
This does not help you because the civil court does not have jurisdiction to declare citizenship.
My lord, then some of the cases, my lord, I have, in fact, I have also annexed, my lord, same in one of my other case, my lord, regarding the civil court, my lord, judgment, which was, my lord, passed way back, my lord, in those periods, my lord.
Even if you get us an order of civil court in 1908 when CPC came, even then it would not be admissible. The reason is that declaration of a civil court is otherwise barred under the Representation of the People's Act. No act of the what you call no act done under the Representative of People's Act
My lord.
is subject to jurisdiction of the civil court because the jurisdiction under section 80
Yes.
of the Representative People's Act is vested in the High Court.
There's no judgment of this High Court also.
Yes,
There
yes,
is
that is
also a
there.
judgment of this court.
They're nullifying that. But, my lord, in those days, my lord, there were, my lord, some of the, my lord, proceedings which were exercised by the civil court, my lord, then
You have a
in many
degree,
districts, my lord.
you have a degree, but it can't be enforced. That's the difficulty here. It could go, Representation of the People Act,
Yes.
Representation of the People's Act.
Yeah.
You have it?
Yeah.
Section 80 or 81, High Court jurisdiction. 83 is election petition.
80 election petition,
80 is election petition,
yes.
High Court.
80A High Court to try election petition. Present 81 presentation of petition.
Representation of People's Act. 50, one,
Check that.
50 के खाली jurisdiction रहता है ऐसे. ना ठीक है सर ऐसा.
Election petition.
Disclosure application. Section 5, application করব পারে। And it will be fine. The government will take an application and it will be a question by any court. Five, six, and 7, 8. 5, 6, and 7 is here.
You're having it. The election.
You see, we'll tell you
Mine,
something. You have the Citizenship Act with you?
mine.
You have a
I don't
copy?
have right now, Mullah.
So you don't have it right now. Please give it to him. Uh, Now you see, the mode of conferring citizenship
Yes, Mullah.
will only be under section 3, which is by birth,
Yes,
4, which is by descent,
yes,
5 is by registration.
yes,
Now your case is that you came into India
yes,
25, 26 years back, and therefore you need you are a citizen of India. That is your case. You have read that order? No.
no. Mullah.
This
That is not correct.
exhibit 5F, you have
Exhibit
not
5,
read.
Mullah, I could not collect, Mullah.
Exhibit F is that your statement is that you came to India 25, 26 years ago. You stayed in the house of so and so, one Hamid Ali or someone.
Prior
And
to
then,
70.
therefore, as you are staying there, you need a declaration that you are a citizen of India. And that was allowed.
That
Correct.
was, Mullah, prior to 70, if I suppose.
So whatever way,
Yes.
age of the order is not relevant. Now the question is, come to section 5, which is citizenship by registration. Then you will find 6, citizenship by naturalization.
Yes,
Then turn over 2 or 3 pages, you will find section 7A,
yes,
registration of overseas citizen.
yes,
Correct.
yes,
Now you come to section 14.
Disposal of application. that's-
Applications are 5, 6, and 7. So if
Yes.
you have to have citizenship, you have to apply. And last 14.2, last line is central government and such application shall be final and shall not be called in question to any court. So therefore, there can't be a decree for citizenship. Somebody just can't come to court and say that, well, I want to be today, I under the UN, what is that called? UN Declaration of Human Rights. I can renounce my citizenship. I can go to any country and stay there. And therefore, you can't come to civil court and say that now I want to renounce Indian citizenship. Go to US and become a US citizen. Give me a declaration. That is just not permissible.
My lord, probably, my lord, that is,
There
my lord,
cannot be a decree for citizenship.
there cannot be a decree, my lord, with that I admit, my lord, but the issue was decided by a competent court of law, my lord. then.
Judgment is a
Then-
nullity. Without jurisdiction, if something is decided,
Yes.
even today we can declare this to be a nullity. It's
Anyway,
a
my lord-
fraud on the constitution.
I'll try to satisfy your lordship on this ground on the other day, if possible.
This is a fraud on the constitution. You will find us declaring it. Okay, when do you want?
My lord, on next Tuesday, if possible, because I have some difficulty on Thursday, my lord.
Okay, Tuesday. Both sides are represented. As to whether by a decree of civil court, citizenship can be conferred.
Regarding the other examinations,
Conferred. On the Learned Counsel for the petitioner, pays for some time to address the court. Like matters is adjourned today, list on 26/8/2025.
my lord. Indeed.
May I please, your lordship? Lordship, item number 7 and 8. Can it be fixed on Thursday, lordship?
Okay, then we adjourn all the matters. But next time we will be in difficulty. We will be no adjournment court on Tuesdays and Thursdays.
No, lordship, can it be on Thursday?
And she's
Date to
asking-
be-
That's why we are saying, we will adjourn the matter today, but take note that on any Tuesdays and Thursdays, we are taking up the matters. It will be no adjournment days.
Wait, could you mention the matter?
And
They can-
you'll have to read the brief and come. You'll do it?
Yes, lordship.
You assure us?
Yes, lordship.
Okay. Like in कौन बनेगा करोड़पति, they ask you lock किया जाए? Yes? Okay. Item number
7 and 8, lordship.
7 and 8. Okay. Miss
B. Hajarika.
B. Hazarika, learned counsel for the petitioner, prays for adjournment and assures the court that on the next date of listing, he will be prepared to do the matter. Just on. Accordingly, the matter stands adjourned today. List on. Give it any Tuesday and Thursday. Okay. We are adjourning other matters. When did you join the bar?
Last 2 years, lordship.
2 years back. Okay, then you are sufficient exposure. Next time we are hearing you. Be prepared.
Yes, lordship.
And